Hello again, everyone. We're back again to talk about some elements of the Renters' Rights Bill. With me today, I've got Annie Coate, who's our Operations Director, loving all the legal stuff that's being changed. And we've got Simon Joyce, who's our lettings guru, been with us for over 25 years and has seen it all. So, very welcome to you both. Now, today, we're going to talk about if a landlord wants to either sell his or her rental property, or move back in. Now, these rules are changing quite dramatically. So, as usual, I've already done a video on this to talk about the sort of facts. So, we're going to play the video. If you've already watched the video, please feel free to forward until we start actually chatting about it. So, yeah, let's play the video. We'll take it from there.
Okay, so let's dive into this one. Now, in my previous video, I mentioned about the various grounds or legal reasons that can be used when serving a Section 8 to regain possession of a property, and the difference between mandatory and discretionary grounds. Now, in this video, I'm going to delve into arguably one of the mandatory grounds that will be used a lot in the new Renters' Rights Bill. And this is when a landlord either wishes to sell the property, move back into the property themselves, or move in a family member. So, landlord decides to sell the investment property currently occupied by a tenant. Now, in the old world, simple. Serve a Section 21, Bob's your uncle, but not anymore. Now, in the new world, this is called a mandatory ground 1A. When used in the Section 8 process, and it entails a new 12-month protected period, which will be introduced at the beginning of the tenancy, during which landlords cannot evict tenants to either sell, move back in, or move relatives in. Also, a 4-month notice period, will be required before possession proceedings can even start. Now, a couple of important points to clarify here, which I know from my social media conversations have been rather confusing. So firstly, the 4-month period must expire after the 12-month protected period. Now, what that means is that the 4 months notice can be given on the first day of month 9 of the tenancy, which then means that the notice will then expire at the end of the 12-month protected period. It'll be in sync. Then and only then can possession proceedings commence. Now, another important point is the date on which the Renters' Rights Bill actually becomes law and how this relates to the 12-month protected period. So, if the bill becomes law on, say, the 1st of May 2025, the 12-month protected period doesn't start from that date. It starts from the original start date of the tenancy. Even though they're all going to switch over to effectively periodic, you go back to the start of the tenancy to see when that 12-month protected period starts. So, in this example, if the tenancy start date was the 1st of Feb 25, for example, this is the date that the 12-month protected period begins. If a tenant has been in the property for over a year on the date that the bill comes law, the protected period won't even be necessary. So, what if all these correct processes are followed and the property ends up not being sold for whatever reason? Well, landlords will, agents will be unable to remarket or relet the property for a new restricted period. Now, this restricted period is 12 months from the later of either the relevant date in the notice, which is the date 4 months after the notice is served, or the date when a claim form or particulars of a claim are filed with the court to bring proceedings for possession. It's rather confusing. So if a property is remarketed within this restricted period, it will be deemed an offence and penalties will ensue. And as I've said before, these penalties can be very steep indeed. So it comes down to, if a landlord wishes to sell the property and use ground 1A, what evidence can a landlord provide the court of an intention to sell? Now, the bill does not mandate what evidence needs to be provided to sell a property, but examples of what could be provided are proof that an estate agent has been instructed or proof that a solicitor has been instructed. However, at the end of the day, there's no evidence on earth that results in an intended sale actually completing. So it's a bit of a strange one. At the end of the day, the bill allows landlords to use ground 1A to sell a property with vacant possession if they can convince the court of their genuine intention to sell. However, it still doesn't negate the restricted period being applied if the property doesn't sell. Okay, so what about a landlord wishing to move in themselves, move back in, or move in a family member? Now, the 4-month notice period, the 12-month protected period, the 12-month restricted period for remarketing all remain the same. Now, just for clarity, moving in a relative, the lawful occupants in this scenario are, and bear with me, the landlord, the landlord's spouse or civil partner, or a person with whom the landlord lives, as if they were married or in a civil partnership, the landlord's parent, grandparent, sibling, child, grandchild. Right, this one is straight from the bill itself, and it's off to Hogwarts we go. Now, a relationship of the half-blood is to be treated as a relationship of the whole blood. Half-blood share one parent, for example, same mother, different fathers. Whole bloods share both parents. Now, where muggles come into it, I have no idea, but that's what is stated. Now, these grounds for possession may sound very complicated, and you probably have to read it a couple of times to actually understand what it means. However, it's the same advice as I've given previously. Understand the notice periods, understand the timescales and what they mean. Amass as much evidence as you can to support your claim, and be very organised with your documents. It's massively important moving forward.
Wow. Don't ever sell your rental property. No, it's... I don't know whether it's a biggie or not. I think it is. I think there was at the beginning of the video, there was a bit that says 82%. I think it was 82% of the Section 21s that we served in 2024 were to do with this exact issue, that landlords wanted to sell or move back in. So in terms of what's happened previously, it's obviously quite common.
Yes, but I do think, your statistics are going to be slightly skewed for what's happened within the economy recently and mortgage rates and everything like that, because I think obviously the impact that that's had in terms of remortgaging, buy-to-let, sometimes it just is not financially viable for them to keep the property. So I think now that's levelled out, I think you'll probably get a number of landlords that maybe want to jump ship before the bill comes in. Or they are deciding now they want to sell because of the bill. But I think that 82% will have been, it's going to be higher.
Oh, there's loads of reasons, obviously.
But in previous years, and we haven't had that many Section 21s due to sale. I don't think it's the restricted period for sale that's too scary. I think the restricted period for the reletting is scarier. Because, we get it quite often where landlords will have the intention to sell, opt to sell, and then for whatever reason can't sell. So then they want to bring it back on. And obviously it's going to be the evidence that's required for that although we've got some information and it's not 100% clear at the moment how that's going to be processed. And that's the concerning bit, in my opinion.
Yeah, I agree. I think, for most landlords, it's a genuine intent to obtain the property back for one reason or another. But as you said, it depends on this protective period and what evidence is needed to state, well, I did try and put the property for sale, didn't go through. Can it be flipped back for rental within that 12-month period without being fined?
Well, this is where the ambiguity is, because not every intention to sell is going to lead to a sale.
No.
And actually, quite often with investment, it doesn't.
No.
There's a lot of situations where actually it doesn't lead to a sale.
Mm.
So you're going to have a lot of people that are potentially caught out by this.
But like you just said, Si, the whole underlying theme of this bill, or one of the underlying themes, is evidence. Basically, every Section 8 is going to go to court, and courts rely on evidence. So it doesn't mean to say that if you've got a genuine intention to sell and it falls through, that you're going to have to sit there and wait to re-let it for that restricted period. It reads as though if you can prove a genuine intention to sell, and not, I was thinking about selling, it's what that evidence is not mandated in the bill.
Yeah.
But it's like instructing a solicitor or instructing an agent or whatever. It might be that the only evidence that is acceptable is the landlord to sit in court under oath and say, I've got a genuine intention to sell. I want to sell my property.
Yeah, I think...
And even that is questionable. I mean, it's obviously been brought in to stop landlords using it as an excuse to get rid of tenants. How it can be proven and evidenced, I think
I don't think, obviously, like you said, it's ambiguous. I don't think it won't be realistic to allow it to get to a landlord sitting in court, because as we know, with when the Conservatives were in power, they wanted to do a court reform before this bill came in, and we're already speculating how the courts are actually going to cope with the fact that every single eviction notice is going to go to court. So that's already a query. I think it's the process of how you evidence it that's going to be important. But I suppose, is the answer going to be, well, just because that sale's fallen through, or just because you haven't been able to sell it for those 6 months, and it is irrelevant. You've kind of committed to that intention. But it's a hard one, I think. It's going to be difficult for people to decide what they're doing. And as we all know, your personal financial situation can change overnight sometimes.
Exactly,
So it's one of them.
Absolutely. I mean, we talked about this in a previous podcast. Do you think there'll be more deals done between landlord and tenant? I want to sell my property. I'll let you off 3 months' rent if we agree to mutually terminate, and we'll do it that way. Because obviously, if you agree to mutually terminate, or you agree that the tenant gives 2 months' notice, but they get an incentive, financial incentive. I mean, I don't know. I don't even know when the bill becomes actual law, whether that can even be a thing or not. But if the two parties mutually agree on something, then I'm sure that's acceptable. So,
well, if there's a mutual agreement by both parties under any legal contract, then the rest of it kind of somewhat becomes irrelevant. So if both parties are going to agree to end that on a certain date, then that's their prerogative. But I suppose the landlord would still be, that would cover them for the 12 months to sell, but it wouldn't cover them for the 12 months to relet.
It's going to be a very, very sort of hard one to police, I think.
Yeah.
But
I think also I think some landlords are also going to open on the basis that they sell it to another landlord.
Now, if that's the case, the 12-month prohibited period doesn't apply.
Exactly. So hopefully, if you've maintained your property, bang on from the previous ones about maintaining it, and you rent at a level where it's justifiable for the yield, you'd always get the landlord's interest in buying them. You've got another angle of getting.
Yeah, you have it, and the rules as they sit at the moment state that you can sell the property to another landlord or to anybody, as long as they continue with the tenancy that's in place.
Yeah.
And the 12-month period doesn't come into it. It's just a change of ownership, and it carries on.
Yeah.
So ideally, if you want to sell, you try and sell to another landlord, and then
But is there then some ambiguity there in terms of if you serve a notice and then end up selling to a landlord? Does that 12-month reletting period still apply? Because
the sale doesn't go through.
No, so if you sell if you sell to an individual, you've served notice though because you've decided that you sell them. It goes on the open market.
You still have to serve 4 months' notice, even if you're selling to another landlord. But
well, you wouldn't have to if it was a change of ownership though, because you wouldn't want to evict that tenant.
no, but as long as that tenancy continues, then you're okay.
Yeah. So if you
We sell it to another landlord.
the answer is sell it to the landlord, but if you've got the type of property that's going to go on the open market, you don't know whether you're going to sell to another landlord or not. So I'm just wondering then if the buyer then proves that they're going to relet the property and it's been relet before, does that 12-month reletting period still apply on?
Well, this is where all the practical.
If anyone else is not confused, I am confused.
Yeah, it's I mean, we talk about.
I get the concept. The concept makes sense. The practicality of it, the practicality of it is to be questioned as and when it comes in.
I think just to reiterate a little bit in the rules as they are at the moment, I keep saying that because it's not law, but again, I don't think this one will change. So the 12-month protected period starts from day one of the tenancy, not when the bill becomes law.
Yeah.
So if a tenant's been in the property for
like 12 months,
year, 2 years, 3 years, the protected period doesn't come into it because the tenancy started all those years ago.
What?
So that's an important one, which is going to obviously affect a lot of tenancies. Obviously, the 12-month protected period will kick on any new tenancy after the bill becomes law, and that's where that sits.
I think one thing just to clarify as well, if you've got a renewed tenancy, then the 12 months starts from the renewal start date,
which is effectively a new tenancy.
Yeah, but just obviously it technically is a new tenancy, but just in case anyone was just sat there thinking, oh, actually, but they moved in 6 years ago, but I did a renewal 6 months ago, it would start from the renewal start date.
Yeah.
Yeah, as far as we're concerned, obviously it's technically a new tenancy, but...
Yeah, and again, we've mentioned this on a couple of other podcasts. A lot of new legislation comes down to case law when something's actually brought to the court and it's deemed in favour of one party or another. And obviously, people then start referring to such versus such and together. So, we'll see what happens. I think it's a tough one to evidence. It's just a tough one. But I get the concept of using it.
The reasoning behind it.
Reason to evict tenants just because you say you're going to sell it.
I think, like you said, Simon, it's more reason to make sure the property that you're letting out is in the condition that it needs to be. Your rent's where it needs to be.
Yeah.
We are still getting landlords that are saying, they've been really good tenants for 7 years. And again, it's a lovely concept to work by, but when the government's implementing such stringent and heavy legislation, it becomes more apparent that actually you can let one property, but it's a business. And if you're kind of in a position now where your yield is low and then you decide that you want to sell, not only are you going to be affected by this, you're then going to be affected by the fact that you probably won't be able to sell to an investor.
No, because
the yield's not going to be there.
No, it's not a good enough opportunity.
And if your property isn't in very good condition, then you're probably not going to sell it at all because you can put it on the open market. Then you've got to consider auction. There's loads of things to obviously look at. So I suppose it's just, positioning yourself as well as you can so that if you did need to sell it, you're as best off as you can be, basically.
Yeah, I mean, we talk about rent increases on a future podcast because that's also obviously a contentious thing. But yeah, it's a good one, that. So again, I'll reiterate, it's not law yet as we sit here recording this. It's going through the House of Lords as we speak. I don't think this one will change, but if it does, we'll be the first to let you know. So, as usual, any questions, give us a call. Any queries, any explanation of what's going on as we see it, we're always happy to help. So give us a call and we'll see you again soon with another podcast. Thanks for watching.
Auf Wiedersehen.